I would like to explain about the agenda and about the mediation session. The agenda is that which we frame when hearing the statement.
Mediator, please maintain eye contact with the parties.
Okay.
Please maintain eye contact.
Now I would like to describe you about the caucus, that what is caucus. In case of deadlock, the parties client and the council can call a caucus, which means that the private meeting will be held between the council and the client. Now moving forward, despite being an informal process, we will be setting up a few ground rules that must be followed throughout the session. So the ground rules goes like, we have to be strict with timelines. The parties are required to maintain the decorum of the session and avoid the use of any unparliamentary language. Number 3, the parties should be respectful towards each other and give equal opportunities towards the other party whenever their time is. The parties may also call for a private caucus if they have reached a deadlock. So now I would request my requesting side to give the opening statement. Thank you.
Good afternoon. Am I audible?
Just take it towards yours.
Good afternoon, everyone present. I would like to thank the mediating pair for announcing the conduct of today's mediation session. I would like to thank Mr. Kumar for agreeing to this mediation session, and I would like to introduce myself as the counsel for team number 42, and especially the counsel for Ms. Reena Malik, who will now introduce the facts of the case and announce what her demand is.
Good afternoon, everyone. First of all, I would like to thank the mediators and the council and the party to be present in the mediation session. I am Reena. So basically, Sharad Kumar, a resident of Vikas Nagar, owned a 1200 square feet house. Abhimanyu Singh and Radhika Sharma are neighbors of Sharad Kumar. And on 25th July 2015, I entered into a sale agreement for the purchase of the land for consideration amount of rupees 80 lakhs. As earnest money, I already paid the part of that 15 lakhs, and and after that I promised to Sharad Kumar that I would be paying the 65 lakhs after the registration and measurement of the demarcation should have been done in the 6 months period, and this 6 months period was given to me for applying for the loan. And on 22 December 2006, I received the information that Sharad Kumar has already agreed to sell this land to his neighbor, Mr. Abhimanyu, for the consideration amount of 95 lakhs. On obtaining this news, I wrote a letter to Mr. Sharad Nivas that my loan from the bank is not yet approved.
Are you done with your opening statement? Then continue, please.
So, and then on 30 December, the registration of the sale deed was fixed.
Please don't read the opening statement. Try to narrate the facts as much as possible by yourself. Try to, please.
So I said to the registrar to not register the sale deed, but still they sell the land to Abhimanyu, and so here I prayed for not. So my demand here is that I want
can be done later. Like the compensation, those things can be done later. Let the opening statement be done first. Mediators, please be proactive in ensuring this.
Okay. So now I request respondent side to give their opening statement.
Sure. So before that, should we begin or should we wait for? Is that okay? A very good. It's okay. I think I'm.
It's recording.
There's a recording requirement.
A very good afternoon to everyone present here. My name is Yuvraj Chatterjee and I will be the counsel for Mr. Sharad Kumar today. At the very outset, I would like to thank the mediators for explaining the mediation process to us and for making my client and the opposite party client feel comfortable and for putting their minds at ease and ensuring that all confidentiality will be maintained in today's session and for also clarifying the ground rules for today's mediation session. I would also like to thank the opposite party. Despite it being a court-referred mediation, without their cooperation, today this mediation session would not be possible, and for that, I am extremely grateful to my opposite party. At the very outset, I would like to state my role as a mediator today, as our counsel today, I beg your pardon. I am on a mere advisory position today. I will be acting as a guide to my client. I will be following instructions for my client and not making any decisions for my client. I will merely be acting in an advisory capacity, and whatever I say will be a reflection of what my client's demands are. At the same point of time, I understand that a lot of laws are not required in a mediation session because we're trying to reach to a settlement amicably. However, I will have to point out certain laws from time to time in order to ensure and protect my client's interest and ensure that this discussion is in consonance with the law. Now, I would like to request my client to introduce himself.
Thank you, Counsel. Good afternoon, everyone. I am Sharad Kumar. My code would be C3. Thank you, mediators, for explaining the process of mediation in front of us today. We are really grateful. You have explained it very beautifully. I would also like to thank Mrs. Reena Malik for having the faith in us that we can resolve this dispute and come to an amicable solution together and resolve the differences between us. Like rightly pointed out by Mrs. Reena Malik, I would like to reiterate the facts again as to what brings us here. Reena Malik proposed to buy my property at Vikas Nagar on 25th of July 2015. And we entered into a sale agreement and we promised the amount to be rupees 80 lakhs. She gave rupees 15 lakhs as an earnest money, after which, after 6 months, she was supposed to get back to us, which makes the time 25th of January 2016. And then we were supposed to get the registration done and complete the sale agreement. But that did not happen. We waited for 6 months, we waited for 8 months, we waited for 10, 11 months. And I am currently in the position I am in. I am in a lost position. Can I take 1 minute to wrap up?
Please make it 30 seconds.
Alright. So we waited for 11 months completely for her to return and pay the amount 65 lakh rupees which was pending, but she did not. And the position that I am currently in, I am in a loss. So I demanded what to do. What was the best position I could think of is to sell off my property that was right in front of me to Abhimanyu Singh, who is my neighbor, who has been pestering to buy the property for so long. So I just did what I had to.
Please stop. I think we should move to the next. Mediators,
Thank
please be a bit proactive because if you are not, then we judges should not be intervening every point. Please tell them.
We watch time to.
When they are saying it's time's up, then we should not be the person telling you that they should stop. You should be the person who should be telling them that now we need to move to this thing.
Okay.
Please make it happen.
Extremely sorry, we apologize.
No, that's fine.
We'll keep it in mind.
I would like to thank both the parties for their opening statement. So based on the opening statement, we mediators have come to two agendas. One is that specific performance of rupees 15 lakh should be paid to Reena.
And the second one is that before registration of sale date, the defendant will get the suit land measured and demarcated from the revenue officer by formally filing the application before the revenue court of respective jurisdiction. So now I will.
Are the parties in consonance to the issues that have been raised?
We are not. there is a factual inaccuracy with that. The land, the suit land which we are talking about, has already been sold off to someone else. Therefore, the point of getting it measured now does not arise.
So mediators, when you are putting any agenda or any issue, you have to take them into the loop and then prepare it. It is not preconceived.
If I may suggest an agenda to our session today, I think a more appropriate discussion for today's mediation session would be a discussion on what Mrs. Reena Malik wants at this point of time and what we are willing to afford or what we can afford at this point of time to give to you. If that is agreeable to Mrs. Malik, then I think we can set that agenda and have a discussion on that.
That is agreeable with us. Thank you.
So since both the parties have agreed to the settlement process, so
Yes.
they also agree. So there's no point calling the private caucus session because both the parties have agreed to the settlement process.
Mediator, they have only agreed to the points on which they will be discussing. They have not yet discussed or settled the issue. Settlement will
Okay,
happen.
since the agenda has been discussed, so we would like the interesting side to move forward.
Alright, as I have already made it clear, we were not notified when when Mr. Kumar went ahead with the sale to his neighbor. We should have at least received the notification that he was going ahead with such a sale outside of the agreement which he had already agreed to. And we were also waiting for the approval from the bank for such loan. We were not trying to escape accountability in any way, shape or form. So, and we also sent a letter properly pointing out what the delay was, and still he went ahead with the sale, and for that I believe we are entitled to a certain compensation.
Mrs. Reena Malik, I have tried to reach out to you throughout the 11 months when I was facing loss, when I needed the money for my own personal purpose. I was in a situation of loss, but we did not receive any communication from you. Therefore, on 22nd of December 2016, we ourselves let you know about the settlement, about the new property that we are about to sell to a woman. You're saying through a third party. That information is sent by us ourselves so that you're aware of what is happening, and that also after a wait of an entire 11-month time duration.
But I wrote a letter to you and you didn't respond to it. And
I understand your concerns, Mrs. Malik, and we apologize for not responding to that letter. However, for our mediators and for the judges, let me just clarify the timeline of this entire thing. So, on 25th July 2015, Reena Malik and Sharad Kumar have entered into a sale agreement. On that day itself, it was decided that after 6 months, the sale registration was to be done on payment of the remaining amount. If we calculate 6 months from the date of 25th July 2015, we come to 25th January 2016. On 25th January 16 till 22nd December 2016, which is an 11th month period, including the 6 months, then it becomes 17 months. In this 17 months, there was no intimation from their side that the bank has not accepted their loan, or they are still waiting for the bank to process the loan, or for any other fact of that concern, of that nature. And we, on our part, have tried to communicate with them multiple times. Mrs. Malik, we have tried to communicate multiple times. However, the communication has failed for some reason. It has not reached you. However, on 22nd December, you have received this information from a third party, and that third party was working on our instructions to come and give you this information.
The information, I beg your pardon, the mic is not working, but the information.
I think the client can also speak because they're addressing the client directly. So the client can speak. Yeah.
so I was dealing with some personal problems and troubles, and that's why I couldn't communicate with you. But when I sent the letter to you, you should have responded me. I understand
I understand, ma'am. I am here not to cause any injustice to you. We completely understand your situation. But you also have to realize where we are coming from. We waited for you for 11 whole months. So let's not, I don't think there is any result that going to happen if we keep on continue discussing this. Let's just move towards a solution and let's look forward what you want from us right now and how much can we negotiate, how much can we reach a settlement that is beneficial to both of us. Is that agreeable?
We completely understand the issue. It is honestly, there is no point. However, we would like to make it clear that due to our own personal struggles also, we couldn't, my client couldn't respond to the letters at this time. Regardless, we will settle for a certain amount of compensation for the troubles that we faced.
Alright, so before we move further in discussing what the settlement process is going to be like, let us just understand the mistakes on both of our parts. So this sale agreement, which was to be registered 6 months later, had certain clauses in it. Now, as we know, the law of the agreement, the words of the agreement is the law, and we cannot move beyond that. The words of the agreement categorically states that if, in case of breach of contract, the earnest money is not going to be refunded. Now, as part of an oral agreement, we had settled upon the position that after 6 months, you will pay the remaining amount, and because of that, we are holding this property right now. We are not selling it off right now. We didn't sell it off for 17 months. We held it. We didn't sell it off on the 7th month or the 8th month. We sold it off after 17 months. And understand the fact that economically speaking, a property, a land, which is in such a like crucial area, has an appreciable value. A property which is sitting for years or months after end will not have the same amount of money. Your client had offered me 80 lakhs at that point of time in 2015. Another client who has been pestering me for years, my own neighbor for that matter, my client's own neighbor for that matter, who was pestering him for years to sell that property, and he had not sold that property for so long because your client had promised to pay that amount of money to us. However, after 17 months on not receiving that amount, on not receiving any intimation from your side, on a breach of contract on your part for not paying that amount of money, I don't feel that any compensation should be given to you. Rather, if your demand for earnest money, that would be a more logical demand on your part, I believe. And Mrs. Malik, please try to understand that this property has already been sold to someone else, right? This registration of that deed has already been done. Now, today at this point of time, you being a party who has breached the contract cannot ask for compensation from us. There are several laws which protect my client from any such claims of such nature. Section 54 of Transfer of Property Act categorically states that a sale only gets complete once it is registered. Before that, there is a contract for sale. Now that contract for sale can have breaches in that, but that contract for sale in and of itself, does not create any interest or any charge on the property. Therefore, standing as it is as of now, you have no charge on the property. You have your earnest money has been paid to us, and I understand that.
I think
I
it's
would like to
already.
interrupt. So, if counsel, if the matter involves substantial question of law, then why don't you go to litigation side instead of coming to mediation? So there is no point stating the section here.
I'm extremely sorry, mediator, but this case had gone to litigation. This mediation is a court-referred mediation under Section 89 of Code of Civil Procedure.
Yes, but
And
the stance is mediation right now. There is no litigation point.
I know there's no litigation point. I'm not telling them that I'm going to sue you under so and so section. All I'm saying is that there are laws which will prevent you. I'm saying this for her benefit, for Mrs. Reena Malik's benefit, because if she decides not to settle with us in today's mediation session and then go ahead and file a suit against us, I'm informing her that there are laws which are against her, which will not benefit her. And all I'm trying to do is reach an amicable solution today. I don't want any of them to go back home upset. I want both of them to go home with a smiling face on a Friday evening.
That's all right.
So which side would go for the caucus?
Any of you are interested for a caucus session?
Yes.
So you
Yes,
can-
even.
So I would like the responding side to please leave the session so that we can decide.
I would like to make a note that we had a certain issue that was preventing us, that is still hanging over our head, as one would say. I would like to maintain the confidentiality of this information, but my client's daughter is about to get married soon, which is why we were purchasing the house to begin with. However, the loan was not approved on time, and we were having multiple issues with getting the loan approved. And so since at this point of time the sale deed has already been registered, we can't ask for the house back. So we would like compensation to that extent.
But then if you're willing to let go of the house and let go of the compensation also.
However, sir, the sale deed has already been registered.
So you still believe you don't have any right over there, right? So if you don't have a right over there, then how would you have a right for compensation?
From the
It's fine. Continue.
okay, please carry. From the in spite of our correspondence with them about that the fact that the bank had not approved the loan in the first place, they went on with the sale, and I believe that should amount.
Did you inform them that your loan was not getting sanctioned?
Yes.
When?
Where? On 22nd December 2016, when we received the
27 December?
On 23rd you informed when already the agreement for sale was done.
I beg your pardon, yes.
But why not prior to that then?
What you were doing since 25th of September, 25th of July 2015 to 22nd December 2016. You were sleeping.
So because of issues, we were not able to correspond or
Okay.
communicate our problems. So this is our issue. We would like to reach a settlement which would benefit both of us.
So, what is your main point of negotiation so that we can see?
Our main point of negotiation is that we would like to reach a settlement which would hopefully recover the loss that we have already suffered, that is 15 lakhs.
So you are saying that the client, that the request, the responding side should give 15 lakhs compensation.
Before we resume the joint session, I would like to inform the requesting side that if you want this matter which you stated to mediators to be confidential, or like you can reveal that the same to the other party.
Like the clients.
We would like to remain confidential.
Okay, no problem.
So that
So they will like the requesting side to please leave the session so that we can call the respondent.
responding side to move further.
Thank you so much, mediators, for agreeing to this caucus session, and thank you once again for maintaining the confidentiality of this session. Now, at the very outset, I would like to clarify certain things for everyone over here. Now, they are claiming that somehow we are in breach of contract, whereas as per the terms of the agreement, they are clearly in the breach of the contract. They have breached 2 of the clauses of the contract. Now, all they can ask for is the earnest money, which again in the contract is mentioned that in case of breach.
Which the clauses would you like to highlight? They have breached?
Yes, sir. Okay, so the first, the primary clause that they have breached was that we have decided mutually that after 6 months, on 25th January 2016, we have decided that after 6 months, they will pay us the remaining amount, and then we will proceed with this agreement and then get it registered on that day itself. However, that has not been done. Number 2, there was another point of getting the land measured and demarcated on behalf of if the plaintiff demands. The words of the problem were very categorically clear that if, which is the operative word here, if the plaintiff, which is Mrs. Reena Malik, demands, then we get it measured. And there has been no communication from her part to get the land measured by us. Alright? And I would like to clarify one more thing, that the clause had, the agreement had 2 clauses. One was that if the plaintiff demands, we have to get the land measured. Second was that months elapsed on 25th January. So it elapsed 2 days before we had to get this land measured. On 25th January we tried to contact her.
No, that is fine. I have understood the clause. We have explained in detail.
Alright.
But are these two clauses so much, you can say, humongous that you have the right to forfeit their earnest money? And then you proceed with the sale to some other XYZ person.
I think it is because over here we are talking about an amount of 65 lakh rupees.
Isn't it violation of part performance as per Transfer Property Act?
It is not a violation of part performance in any way because when we have agreed into that agreement, it was settled. It was not a contingent contract in any way. It was a contract where we were determined, both we had consensus at item.
I said part performance, not contingent contract.
We don't believe that it is part performance in any way, and they are not claiming. They are not claiming.
They are not claiming. So that is the benefit they are not claiming. That's why I asked you the question in corpus, not in front of you.
Thank you, thank you. And we are not rigid in our stance. We understand that they are facing losses. We are willing to come to some terms with regards to the earnest money, and that is
Please
it.
make your offer to the mediator so that they can.
So mediators, yes, thank you.
We would like to understand the situation, and even though there are, as the facts say and the condition also says, we are not in a position to actually be very rigid, but it's okay. We understand where they are coming from. We are here to settle and we want to get this done with quickly, so we will be able to offer them some settlement amount, but if they are okay with the amount number will be at our discretion. So if they are okay with that, we can move forward with the settlement process.
So before we resume the joint session, I would like to inform you that this session is really confidential, and if you permit, then only the conversation which we had just now, we can reveal that to the other party.
Yes, sure. One more thing I would like to bring to everyone's notice over here. We were given a confidential information. That confidential information stated that there was no condition precedent of getting the land measured. No condition precedent of getting the land measured. Therefore, if that is any of their arguments, that we have breached the contract somehow because we did not get the land measured, that will not be taken into account. And the confidential information also stated something which my client will explain.
Thank you, Council. Yes, the land and the dimensions have already been measured, and this is the confidential information. So if they are trying to get a compensation on the basis of that, there lies no ground because the land has already been measured. So I would like to summarize what we are able to offer here. We are going to give them a compensation, not a compensation, we are going to reach a settlement point, but we are not giving them the entire 15 lakh rupees that was the earnest money. We will decide on the number, which is at our discretion. You can disclose this to the requesting party. Thank you.
Okay. Thank you so much for the fruitful session we had. I would like to invite the requesting side to come. Since the respondent side has authorized us to reveal the conversation, so we are legally authorized to reveal the conversation to you. So what actually the respondent side said that they are ready to settle the matter, but they are not ready to pay entire 15 lakhs amount. They are ready to settle the matter. So what's on your take on this?
I believe we should be entitled to the whole amount because it is a loss on us, and at the end of the day, this is a mediation session where we want to reach a settlement which is mutually beneficial, and it will be a loss on our end if we settle on anything below 15 lakhs.
I understand your concerns. If the mediators allow, I would like to ask them a yes or no question. By not informing us and by not paying the remainder of the money after 6 months, has your client breached the contract?
The terms of the contract have not changed. However,
If the terms of the contract has been breached, then why should we pay you the 15 lakhs? Because the terms of the contract categorically states that the earnest money will not be refunded. However, owing to the fact that my client has a big heart, we are still willing to come to give you something instead of sending you home empty-handed.
however, your client still went forward with the sale even after us corresponding with them about the fact that the loan has not yet been approved
interested in purchasing the house.
I understand that, but so are other people who are not making me wait. And I am in a need, I am in an hour of need. I need the money immediately. Which is why I did not go to anybody else looking for people who are willing to purchase my property, which is situated in a very lucrative position. I only went to my neighbor who has been pestering me for years to buy my property. I finally agreed when I saw your client, Mrs. Reena Malik, not correspond to my messages. I was bound by the conditions.
And to add to that, the fact that you are mentioning that we had entered into an agreement and which is why you feel that you are entitled to that property and which is why your contention lies, just to bring to notice the laws again, so that our discussion is in consonance with the law. Section 49 of Registration Act categorically states the effect of non-registration. We had a sale agreement, not a sale deed. There is a difference between the two. Our sale agreement is a contract of sale, which has not been registered yet. Until and unless it has been registered, you have no right on the property in and of itself. I understand that your client has paid us 15 lakhs and now she has not gotten the property, so that 15 lakhs is a loss for her. Therefore, we are willing to come to some terms with you, even though that is a breach of our contract. Even though the contract mentions that we are not supposed to pay you back, we are still being kind enough to pay you some amount. So please be considerate. Please understand where both the parties lie today. We want to go home happy. We want the client to go home happy.
So what's your take on this, the requesting side?
We are also facing certain issues, of course, that for which we have already, like, the bank is not approving the loan and we were not in a position to pay the complete amount within 6 months, which is why the delay happened. And so...
Sorry, you cannot repeat the same facts which you have already stated.
At this juncture, I would like to just inform Mrs. Malik. I know you are an opposite party and I am not supposed to help you, but as just a friendly, I would like to explain that if this matter is not settled in mediation and you proceed to go ahead with a civil suit of any nature, it will be decided against you. Because the contract, as we all know, is the mother law of any agreement between two parties. And the contract is against you, ma'am. So please be considerate. Please understand where both the parties are at today. Considering your position, we understand you are not doing financially well. So even we aren't doing financially well, which is why we had to sell out that property immediately. My client was facing a lot of losses and was in debt, and she needed money immediately. And Abhimanyu Singh, being the kind man he is, he gave the money immediately. So my question to you, ma'am, and to your attorney is that how much of the earnest money do you want back?
If your property has a value, then my money that I gave you, the 15 lakhs, that also have some value, and it is increasing day by day, and so I think I should get it.
Ma'am, I understand, but once again, you're on the wrong side of the law here. You're on the wrong side of the law, and when you're on the wrong side of the law, you cannot expect to get the same benefit when you are on the right side of law. You are in breach of contract. It is a big thing.
I would like to interrupt. So it's no point to decide that who is at the wrong side of the law. It's only just to decide who is the wrong side of the law.
I apologize.
We would like to hear what compensation we might get if we do agree to the terms.
I feel that on behalf of my client and what my client wishes, since there is a clear breach of contract and the contract states that we are not supposed to give you back any earnest money, zero, but still we are offering you 2 lakhs from your 15 lakhs. And I believe that is a generous enough offer from our part, considering the fact that the contract states that we are not supposed to give you any money.
However, you also have to understand that my client is in a time of need, and we did give the 15 lakhs, and it was not a fault of our own that we could not pay the rest of the money back to you. It was because the loan was not getting approved, and we had
responded that. And
I understand, ma'am, but that correspondence came 11 months later, not after 6 months. If it would have come within 6 months, we probably would have renegotiated the terms and my client would have been willing to.
Correct. We would have been willing to negotiate, we would have been willing to understand your situation as well. Even though there was no communication between Mrs. Reena Malik and myself, we waited for 11 months. I'm sure we would have waited more if she would have communicated with us. We tried reaching us ourselves, but she was not communicating. How are we supposed to know what is happening? And I'm in an hour of need. Please understand that. The 2 lakh amount is also a generous amount we're ready to settle at. This is not something that would make me in a situation of benefit at all. We are still in loss. We are still making the generous amount of settlement because we understand Mrs. Reena Malik's position also.
I don't think you have been trying to communicate with me because I didn't receive any calls or any messages.
you have already
So
said
why you are stating the same facts which you have already stated? These have already been answered. You have already stated the facts in the opening statement. Only she has only answered. I have already mentioned that you cannot state those stated facts.
Ashok, mediator, just be a bit calm.
Okay.
You're little scolding them. Not be that much.
Sorry, sir. I didn't mean. Yes.
Yes, let us all remember that it's a Friday evening and it's almost 5 o'clock. Courts also stop at 5, so we also must stop at 5. And in order for that, I'm requesting Mrs. Malik once again that I think 2 lakh is a very generous offer, considering that there's a breach on your part, ma'am. Please understand that there's a breach on your part, and 2 lakhs is a very generous offer, extremely generous offer on our part. If there was any other client here, I am a experienced real estate counsel, and I've seen that clients are not willing to give any money to the other party.
However, you also have to understand that the 15 lakhs is already gone as a loss for us. So getting back the 2 lakhs is not as generous of an offer as.
I understand that you have faced a loss, but you have also breached the contract. There has to be consequences. There are laws exist because there should be consequences. Otherwise, people would randomly enter into contracts and do not fulfill their promises.
However, there is no point of law. This is a mutually beneficial contract, and I do believe that you have to upscale the amount of bid at least for us to settle, because we are also going for a loss here.
But ma'am, what are your grounds? Why should we upscale? The contract states that we are not supposed to give you back any earnest money. We have upscaled from 0 to 2 lakhs. I think that is
entering into the litigation side. I like to refrain to not enter again.
No, we are not. We are simply deciding.
You are again stating that who is at the wrong side. But please don't state that. This is a mediation.
When I understand, mediator, thank you for pointing that out. However, I would like to state that when I say that you are on the wrong side of the law, I mean you are on the wrong side of the contract, because the contract here is the law. We have all studied Contract Act, right? All the sections start subject to contrary to contrary to the provisions of the contract, subject to the provisions of the contract, which means that when there is a contract is the law. And when I say you are on the wrong side of the law, I mean you are in breach of the contract. And when you are in breach of the contract and I am supposed to give you 0, my client is giving you 2 lakhs, I think that is a great upscale. Please be considerate and please understand our position. My client wants to know what you are willing, what you expect from us.
Please figure out their claim.
Yeah, please
Figure out.
zero in on the claim, because I don't think there is.
Mr. Sharad had already said that 2 lakhs they will be.
Either they take it or leave it, or if they have any other fact.
Figure out.
So if you want to negotiate, or if you want to just say yes to the amount, so you can say, because it already been a few minutes that we are arguing in the same point, but it's not makes any sense to argue much further. So if you want, so we can proceed for further mediation also. So it's on you.
Would you like to upscale the amount to 5 lakhs? So that's why.
So time's up. So now I think we'll be going for closing remarks. Yeah.
So if 30 seconds are permitted.
Closing statement, in that you can finally decide.
Okay.
Closing statement, you can make your closing offer, they can make their closing offer, and mediators can do it.
Okay.
You have got hardly 11 minutes, 8 minutes.
Okay, so now I request requesting side to make the closing statement.
Yeah, please.
It's requesting side first.
Yeah, requesting side should make the closing statement.
Yes.
Let them make the closing statement.
So,
If I may interrupt just for 1 second.
Let them make the offer first. You have already made an offer and they were about to upscale it. So,
Okay, I'm sorry.
Again, we would like to upscale the amount to 5 lakhs as we do realize there has been a breach of contract. However, we have already paid 15 lakhs in earnest money, and settling for 2 lakhs will be a loss on.
So you will be happy with 5 lakh.
Yes.
This is what your condition.
and you will go and you will let go 10 lakhs just like that.
Is happy.
Good.
Okay.
Such a generous
So,
offer.
thank you for your offer.
Yeah.
Thank you for your acceptance as well. Now I request the respondent side to begin with the closing statement.
Okay, so before I thank the mediators and I thank the other party, I would like to state my client's demands. My client is not willing to give you 5 lakhs. My client is willing to give you 3 lakhs. And that is a final offer. If that is not accepted to, then we will have to end today's session and probably move to different mediation sessions. But once again, I request Mrs. Malik to understand that this is the highest you can go. And this is the best deal you're going to get. Because you're in a breach of contract. Contract states you're supposed to get 0. We are offering you 3 lakhs.
But actually, if I talk about the contract, what is the nature of breach that she has done over here? Like the time you are talking about, the time. But if I read section 58, I guess that's what you are mainly a bone of contention, section 58 of the Contract Act.
So let me just
58, 59, I guess.
No, it's like if there is a breach of contract, then it is 73.
No, no, in context of time being in essence.
Okay.
That is when you talk about the compensation.
Okay.
That is for them, not for them. They have not raised it.
time is definitely of
No,
essence.
no, I'm just saying, is it 58 you're talking about in context of that?
No, so section 58 talks about something else. It talks about alternative promise one branch being illegal. That is something else.
I think there is a provision in the contract, please check regarding the time being in essence.
Sure, I will. Just give me 1 minute.
Yeah. Some help from the audience, I guess.
55.
55. Yeah. Thank you very much. So 55, if you see time being an essence to the contract, is it the only essence that makes or breaks a contract? Because there are plethora of Supreme Court judgments which go on to say that time has to be read in light of the consequence of the contract that the subject matter of the contract is. If that is that much material, now they did not communicate, I agree, they are at a fault. But what did you do? You also did not intimate them that we are proceeding with an agreement for sale.
I understand.
Now they are very modest enough, they are quite submissive, so they are not pressing on 15 lakhs. So it's very hard to say whether they will win the case or not in the litigation. But that was a smart point to put forward to keep the pressure upon them. But actually, if I say they are rightfully within their chances, because they can easily press for doctrine of unjust enrichment. They are not doing it, and they cannot now because it's a closing statement. So that's why I'm saying the doctrine of unjust enrichment they did not bring in, and rightfully they are within the claim limit also. The limitation period has not gotten over.
Yes,
Instead, what have you done? You have gained a total of 95 plus 15 lakhs.
So I wouldn't say gained is the correct word.
Plus, you said every year you only admitted the price of land gets appreciated.
Yes.
So maybe the valuation it was done at 90. Maybe this year the valuation has already gone up. So that's why I'm saying. So in that way, I understand. Maybe at that point of time, at that juncture, when you might have been in requirement of funds, but there is nothing to prove in the fact sheet that you were in requirement of funds. Rather, that information is with the other party, which they have not been able to navigate that much well. So that's why. But anyways, yeah, please close your arguments now.
So that is our final offer at 3 lakhs, and once we get the response, I would like to close on our side.
Requesting party.
We'd like to stay on our offer of 5 lakhs, and if it goes for further mediation, we are hoping to settle on that amount.
Even 3.
So what's your take, respondent?
Can we just take a minute?
Yes, you.
Because deciding